Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. One of the most crucial pillars of a fair, just, and productive economy is its labor laws. Whether it's setting minimum wages and encouraging industrial growth, or ensuring safe working conditions and easing compliance for businesses, labor laws are what help balance power between employers and employees. Now, it was starting in 2019 that the parliament began clearing 4 labor codes, which were to replace 29 central labor laws that had been in place for decades. But it's only now, 5 years later, that the government has finally decided to implement them. The draft rules will be published soon, after which the public will get a 45-day window to send in comments before they're finalized. So we are dedicating today's episode to discussing what these codes aim to do and the changes they're likely to bring. Joining us for this conversation is the Indian Express's Aanchal Magazine, who reports on the macroeconomy and fiscal policy with a special focus on taxation and labor. Aanchal, before we talk about these new codes in detail, can you briefly summarize the current landscape of the labor laws in the country?
So actually, labor is a concurrent subject and it is to be governed by rules by states and center. And there are various laws governing this subject. And that was what was probably one of the long-standing demands of the industry, that, one of the things was seen as a restraining factors to scale up also in size and also compliances also. So in that context, the myriad laws were intended to be compressed into 4 codes, and the government had worked towards it since 2019. Code on wages was actually passed in Parliament in 2019, and the rest of the 3 codes, Code on Social Security, Industrial Relations Code, and Occupational Safety, Health and Working Conditions, which we call as OSH Code, were passed in 2020. So it has been in the limbo for so long, and now the government has notified these 4 codes.
So basically what you're saying is that a lot of businesses were frustrated that, look, you have so many of these laws, some by the center, some by individual states, and that is a problem for us.
Yeah, so it had been felt that there was a heavy compliance burden. In many ways, such things create an impediment for capital flows also, for investment flows also into the industry, especially, if some company wants to come from outside and set up a factory in India. So labor laws are very crucial in those negotiations and setting up of an establishment. So probably it was somewhere being felt that they were hampering business efficiency and they were probably discouraging FDI's flows. So in some ways, the course will be now set straight. This is probably somewhere a needle for domestic manufacturing with a much more pro-industry approach as well as a workers' recognition approach also. And one instance I will give you is about the definition of wage. So now wage will be uniformly defined in all the 4 codes. It matters because it is not only important for the workers, it is also important for the industry side. Because if you are, defining working conditions, to have a uniform definition for wage is very important.
And so earlier there was no uniform definition for this?
So now it is because it will cover all workers and across establishments. So earlier there were certain distinctions about, the wage rules applying to certain scheduled employments and above a certain threshold of 24,000 monthly wage. So now to cut across all these definitions, there will be a uniform coverage for all workers across sectors, across genders. That also has been stated very clearly in these codes. And I think there has been a considerable gap in revising the labor laws, which, many have termed as obsolete. Workers, we have been seeing that, since the industries have evolved, gig and platform workers, say, were not covered earlier. Now these labor codes will work towards giving them a formal recognition. Yes, there are certain things which trade unions have pointed out. Those probably, I think, will get sorted out in the transitional period.
And so, Aanchal, let's begin by talking about the first of the 4 codes, which relates to wages. Now, you mentioned earlier that wages will now be clearly defined. So tell us how this code is doing that.
Yeah, so now wage will include basic pay, dearness allowance and retaining allowance. One of the important things that they have stated is that deductions cannot exceed 50%, which deductions like HRA, bonuses. But initially when these rules were proposed, there were certain objections from the industry because a lot of salary breakup, if you see, includes incentives and bonuses, and they wanted those to be included. So a lot of the details now would be seen in the rules, which are expected within a week, draft rules, and then there will be a 45-day window they will get for public feedback, and then another 45-day window for them to get finalized. Coming back to the code on wages, apart from the definition for wage, when deductions get capped at 50%, I think one of the most sought after thing right now is that what happens to salaried employees, and their basic pay will of course see a bump up, but take-home pay will accordingly reduce a bit because social security contributions such as Provident Fund will also are linked to basic pay. And so when basic pay goes up, those contributions go up. So they secure you for the future more, but your take-home pay will accordingly reduce. The exact impact will be much more clearer when the rules are out.
And the other thing that this code for wages does is set limits for how much an employee will be allowed to work, right? I mean, in India, most workers end up working beyond their normal hours for the same pay. Tell us what limits this code sets for that.
Yeah, so code on wages, because it defines wages, it defines a normal working day also, because apart from just the wages definition, say there is a feature now about overtime wages have to be at least twice the wage amount. So to define what is twice the wage amount, you will have to define a normal working day also. And for a normal working day, the minimum hours to be put in have to be 8 hours. The codes actually define the weekly working limit to be 48 hours, which is as per the Convention of International Labour Organization. Earlier discussions in 2021, 2022 had actually revolved around that they will give flexibility about working hours, which is the sense which we are even getting now informally from the officials, that the range for a working day will range between 8 hours to 12 hours. 8 hours is the minimum, 12 hours is the maximum, including the interval for rest. But if, say, a person decides to work for 4 days a week, then the person will have to work for 12 hours a day to meet that 48 hours cap. So then there might not be an interval for rest, but accordingly it will adjust if you are working for, say, 5 days, 6 days, and accordingly the rules will define the holiday and the rest day.
And is that for all employees?
Yes. I'm sure when the rules get notified, they'll be giving some kind of flexibility to industry sectors to define it in their way. But if the government is open to flexible working hours, I think it will be up to the establishments also to define it for their employees. So I think the next 3.5 months are going to be a bit more crucial, because first the 45-day window for people to give in their feedback to the rules, and then once the finalization happens, so a lot of these industry-related provisions, we are made to understand, will actually kick in from April 1. A lot of the provisions don't require these rules to get notified. So then they get implemented immediately. As for, I know the working hour debate about whether it should be more or not, but the code actually caps it at 48 hours a week, which is as per the ILO convention. So government is sticking to that as of now.
Right. And the other issue that employees face across sectors really is when they end up getting paid. Often we see that, weeks go by and people don't get their salaries. So talk about what the code says about when an employer should be paying their employees.
So one of the things you might have heard in the context of labor codes is that it will lead to formalization of workers. One of the important steps towards that direction is about having a documented evidence for it, that you have hired this person. So one step towards that direction is that the code says that every employer has to issue a wage slip, electronic or physical. So in that way, a lot of these unorganized sector workers, casual workers, who may get missed on the paper, will now have a record trail. And otherwise also for the time limit, for wage payments, that also has been defined very prominently, because if you are in a daily shift, the payment has to be made at the end of the shift. If you are on a weekly shift, then before the weekly holiday, the payment has to be made. And if you are on a monthly basis, the employment is there, your salary has to be paid by the 7th of the next month. And in case there is resignation or termination, you have to pay the amount within 2 days. So these timelines will actually help workers get their wages on time. Especially, I think, when there is crisis, or employers probably get it easy by delaying their payments, and, unorganized sector workers definitely will benefit from this.
Okay, so we've talked about wages, how long someone should be working, when should they be getting paid. But the other concern that workers have is social security. And this is especially a concern for gig workers, a lot of people who freelance, which brings us to the next set of codes, which talks about social security. Talk about the kind of reforms it is proposing.
Yeah, so one of the most important things that the Code on Social Security has done is that it has defined gig workers and platform workers for the first time. Aggregators have also been defined. So accordingly, the relation between the gig workers, platform workers, and the aggregators will actually be seen as an employer-employee relationship now. And that gives them access to social security schemes. Government has proposed setting up a social security fund for them. There will be dedicated social security schemes for them, the fund will be funded by contribution from central and state governments, corporate social responsibility. The aggregators would be required to contribute about 1 to 2% of their annual turnover towards the fund, with the total contribution capped at 5% of the amount payable to the workers. The companies have said that they will be contributing to this fund. This will help the government to define schemes for them, which will enable things like accident insurance, old age support. These will be covered now for gig workers and platform workers.
Right, when we talk about companies like Zomato and Swiggy, people have criticized them, saying that, look, these people who you call delivery partners, they are the ones who are actually running your business. They are the ones who are actually delivering, your products, and yet you're not offering them any social security. And the pushback from the industry has been that, look, they're not our full-time employees, and so that's why we don't give them these benefits. And so this reform brings them under the social security net. But you mentioned that, the aggregators will have to contribute 1 to 2%, capped at 5%. But shouldn't these companies be contributing more?
I think it's a beginning. We have to appreciate that also. And the fund will see contributions from center, states, as well as the companies. I mean, if they're linking it to the CSR component also, so definitely other companies can also pitch in. But of course, the aggregators will have this direct responsibility of contributing 1 to 2%, capped at 5%. The shifting of workers between various organizations has been one of the most contentious issues while framing these rules, because how do you say that this person works for, say, Uber and not for Ola? So all those operational issues will need to be figured out. I'm sure the government has probably discussed them in detail with the companies, because there have been many consultations with the companies before, this has been now announced. The rules will be very crucial to watch out for. There is going to be a All India registration for these workers also linked to their Aadhaar linked universal account number. So in that way, now they will have coverage under the EPFO schemes also. And accidents occurring while traveling between home and workplace will be treated as employment-related accidents under this code also. So a lot of social security benefits will probably get defined in a much better way for the unorganized workers, the gig workers, and platform workers.
And Aanchal, the other thing these reforms aim to do is put short-term or fixed-term employees at par with permanent workers, especially when it comes to gratuity, for example. Talk a bit about that.
So the courts actually introduced the concept of fixed-term employment. This facilitates hiring for shorter tenures, which, of course, the critics and trade unions see it as a provision for hire and fire. The industry sees it as a provision for flexibility in hiring based on seasonality. That gives you the flexibility to hire workers for shorter time periods. Now, what government has done is that even if you're hired for a shorter time period, under Code on Social Security, they have provided this provision for gratuity for fixed-term workers and treating them at par with a permanent worker. So if a permanent worker was eligible for gratuity after 5 years of continuous service, that provision has been eased for fixed-term employees so that they can avail their gratuity if they work continuously for 1 year. After that, they can avail it, but this is for fixed-term employees.
Okay, Aanchal, now let's talk about the third code, the one that relates to industrial relations. Now, one of the things that immediately stands out about it is what it says about workers being able to go on strikes. But tell us what stands out to you about it, because this merges 3 different industrial laws.
So yes, it merges 3 industrial laws, includes working journalists and employees in supervisory capacity also, which were not covered earlier, those who were drawing wages less than 18,000. But yes, like you pointed out, the most important point is probably about the retrenchment, the standing orders. The threshold for that has been increased to 300 employees. What does that raising of that threshold actually mean on ground is that earlier you were required to seek prior government permission if you were laying off workers, for retrenchment, for closure in factories, mines and plantations. So now if you are employing 300 workers till 299 workers, you don't need to seek prior government permission. That is what it means. Or defining standing orders, defining working conditions for employees. You don't need to really seek permissions for such minute details till the threshold of 300 workers, which earlier you had to rush to seek permissions for 100 workers threshold. Now, during COVID time, actually also many states have raised that threshold already to 300 from 100. So it's not like that this is the first time that it's happening. At state levels, many states have moved towards this. And in fact, now that the labor codes have been notified, a lot of commentary is about that, how even 300 is less probably. So it might look like a giant leap, but it's probably a small step in that direction.
So this is something that the industry would find beneficial, right?
Yes, this has been seen as a pro-industry provision. This is one of the norms that the trade unions have objected to earlier because they feel that this eases hiring and firing. Because if you don't need prior permissions for a lot of these factors like retrenchment and layoffs and closure of factories, then of course somewhere it is a pro-industry provision.
Okay, and the other changes, as we mentioned, relate to how workers and unions can and cannot go on strike. For instance, one of the things it does is discourage flash strikes.
Yes, so that is also one of the other major change in the Industrial Relation Code, and it relates to the strike. Because now the conditions for a legal strike have been extended to all industrial establishments. Earlier, many of these conditions were applicable only for public utilities, which are very critical, say water, electricity, natural gas, other essential services. But now when they extend to all industrial establishments, there is a certain sense that the government is probably trying to convey, and I think they have also mentioned it in one of their notes, that this will discourage flash strikes. The unions have objected to this, that these norms will limit the power to strike. Now, what are those norms is that A, the conditions have to be met. The code states that workers cannot strike without giving a notice within 60 days before striking or within 14 days of giving such notice. The definition of strike has also been amended to include mass casual leave. This was not there earlier, where, casual leave has been taken by more than 50% of the workers on a given day. So that will get treated as a strike.
And again, earlier these rules mainly applied to public utility companies, but they will now apply to industries across the sector.
Yes, that has been one of the crucial changes. And not just strikes, in some ways, the trade unions, one of the most contentious issues, when the codes were not getting rolled out actually, was this objection by trade unions to this provision related to strikes, as well as there is another provision related to the negotiating council. So the conditions have now been that the trade union with 51% membership of workers will be the sole negotiating union. So in case there is an issue, the negotiations are required, only a large union with 51% membership of workers will be treated as the sole negotiating union. Now, if there are multiple unions in an establishment and one union doesn't have 51% membership, then a council will be formed with representatives of unions having 20% of workers as members each and granting one seat for each 20% of verified membership. In some ways, this limits the powers of small unions. This was one of the very crucial objections by trade unions when the codes actually came out in the first place in 2028 and the rules were published. Let's see how it goes ahead when the new rules come up.
And just talking about strikes again, I mean, now that they're counting mass leaves as a strike, and this is something we've seen happen in the aviation sector, for example, employees going on mass casual leaves. So would that count as an illegal strike now?
Yes, possible. In my view, because it will be a mass casual leave, it will get counted as a strike, but it won't be a legal strike because adequate notice would not have been given. So then it will be dealt accordingly.
And now let's come to the final code, which relates to worker safety and working conditions. We know that in India, a lot of industries don't follow appropriate worker safety measures. So talk about the changes that these codes hope to bring about.
So yes, under the OSH code, which, defines the working conditions for employees, especially safety conditions and in hazardous conditions, the code has approved appointment of women in night shifts, which is before 6 a.m. and beyond 7 p.m., subject to their consent and provisions for safety. This was not allowed earlier. Some of the states have actually allowed night shifts for women in the past few months. So clearly, states and center are moving in the same direction. The part about treating women employees at par with other employees is about removing the distinction of gender also, which we saw the provision in Code on Social Security also. About the night working conditions, that gets defined in the OSH code. There are a lot of provisions for contract workers also in the OSH code because, say, the definition of interstate migrant worker has been now expanded to include those employed by an employer directly as against through contractors only at present. So a lot of these interstate migrant workers would not get counted if, the contractor was not probably accounting for them properly. So those things will now get better. Contract labor norms will now apply to contractors employing 50 workers as against 20 at present. One of the most important pro-industry provisions being seen right now in the OSH code is that core and non-core activities have been very clearly defined of an establishment. When we say non-core, we refer to, say, sanitation, catering, which are typically, the employers employ contractual staff for it. But even for core activities, the code is actually allowing for employment of contract labor subject to certain conditions. The code mentions those conditions. So in a way, the industry will have flexibility of hiring more of contractual staff based on the needs, requirements, and the seasonality, as we saw in another provision of fixed-term employment.
And when we talk about safety, we have to talk about the health benefits that companies have to provide to their employees. What kind of requirements does the code set regarding that?
Yeah, so there are provisions for formation of safety committees and all. And also, every employer now will be required to provide annual health examinations free of cost to employees. Every factory employing 500 or more workers, employees employing 250 or more construction workers, or employees employing 100 or more mine workers will need to constitute a safety committee consisting of employers and workers' representatives. Another thing I think for workers' benefit is about issuance of mandatory appointment letters. Every employer has to now do that for every employee. Earlier laws did not explicitly mention these words, did not mandate letters for every worker. So now with this, it will help cover the unorganized sector workers, and the letters will carry details such as employee details, designation, category, wages, helps bring a lot of workforce on paper, which was probably hidden from a lot of counting. Of course, parallelly, we have seen India's statistical system also now capturing the unorganized sector workers much better now. But this will help capture that unorganized sector workforce in a much better way. For example, one of the most important changes which has happened is that plantation owners can now join ESIC coverage, which is, providing the health schemes to unorganized sector workers, employees, state insurance corporation. So earlier law did not provide for them to opt for it. Now they can voluntarily opt for that scheme. So it helps expand social security benefits to such workers.
And Aanchal, one thing is drafting and bringing out these codes. But who keeps a check on them? What challenges will the government face in ensuring that the industry actually follows this? Because the majority of the country is in the informal sector. And although the government is pushing towards formalizing that, but how crucial will that implementation be?
Yeah, so I think one of the most criticized element of labor laws is about labor inspection. It has been criticized about being arbitrary and being discretionary. But the government is stating very clearly that, they would probably push for a web-based inspection, calling of information only for, necessary cases. There is also some kind of changes about the prosecution, because first-time offences will be given improvement notices instead of straightaway prosecution or straightaway imprisonment, or penalties would be opted for than imprisonment. Of course, except, cases which involve loss of lives and risk to safety. Those cases definitely still fall in the more harsher punishment bracket and very well so required. But for other things, for first-time offences, the government is probably, trying to ease the fear that there is no Inspector Raj, and they're trying to facilitate a more industry-friendly compliance regime. We'll have to see how it works out on the ground. You're right. It's very tough to know right now at this moment that will all the compliances happen to the T. It's not very clear right now, because many experts are saying it will take 2 years for the transitional issues to get sorted.
You were listening to Three Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.